Hello all, welcome to my channel. The topic we are going to discuss today is about the Places of Worship Act. Let us see what is the current issue that is there in the news. Supreme Court agrees to examine validity of Places of Worship Act 1991. Supreme Court on Friday agreed to hear pleas challenging the Places of Worship Act 1991. So, recently the Supreme Court has agreed to hear various cases which are challenging the Places of Worship Act 1991. That is the current issue that is there in the news. Now, let us see what is the Places of Worship Act. The Places of Worship Act 1991 was passed by the Parliament during the Ramajanmabhumi movement. So, this act was passed by the Parliament during the Ramajanmabhumi movement. The act was introduced to promote peace, harmony and brotherhood. So the main aim of the act was to promote peace, harmony and brotherhood among all the religions. The main objective of the act is to maintain the religious character of any such place as it existed on 15th day of August 1947, that is at the time of independence. So, the main objective of the Act is to maintain the religious character of various religious institutions which existed at the time of independence. That is, we cannot change the religious character of an institution that existed at the time of 15th August 1947, that is, at the time of our independence. The Act prohibits conversion of any place of worship or changing the religious character of any place from its status at the time of independence. So we cannot change the status of any religious institution at the time which existed at the time of independence. Suppose we have a temple which existed at the time of 15th August 1947, that is at the time of our independence. After that, it is not able, we cannot make any claims such as it was earlier a mosque and we should convert it back. We cannot make such claims. That is the main purpose of this act. So, to put it simply, the religious institutions which are present at the time of independence will remain as such after that. The main purpose behind the act was to check and control communal hatred. So, the main purpose of the act is to control the communal hatred that was present in the society at that time and promote peace and harmony in the country. So, the main aim of the act was to control the communal hatred that was in the society and to promote peace and harmony among different religions. Now let us see the provisions of the act. The act prohibits the conversion of any place of worship and provides for the preservation of such a place of worship's religious character as it existed on August 15, 1947 and for things connected or incidental thereto. So the act, as we already discussed, mainly deals with preserving the nature of a religious institution which had existed at the time of independence as such. The sections 3 and 4 of the act declared that the religious character of a place of worship shall continue to be the same as it was on August 15, 1947, and that no person shall convert any place of worship of any religious denomination into one of a different denomination or section. So according to section 4 and 5 of this act, any place of worship in the country shall continue to remain as same that was present at the time of independence. The Indian Constitution includes a constitutional requirement on the state to safeguard and protect the equality of all faiths, which is an important secular characteristic. So, the Indian Constitution is basically secular in nature. That is, we provide equal respect to all religion or equality to all religion and faith. So, this act, the Places of Worship Act 1991, uphold this secular nature of the Indian Constitution. Additionally, the Places of Worship Act places a positive obligation on the state to maintain all places of worship's religious character as it existed at the time of independence. So, by the Places of Worship Act 1991, it is up to the state to preserve the religious institution as such as it existed at the time of independence. It gives a positive obligation of the state to maintain such religious institutions as such, which is an essential feature of the secular nature of our constitution. Now let us see the significance of the Places of Worship Act. India likewise chose a strategy of separating the power of religion from the authority of the state in keeping with the principle of religious freedom for everyone. Indian secularism is based on the principle of equal respect to all religion. So the Places of Worship Act 1991 is upholding this feature of our constitution. So now let us see the difference between the Indian secularism and the Western secularism. The Indian secularism is a positive concept which is based on equal respect to all religion, and the Western secularism is based on complete separation of religion from the state. That is, the state will not interfere with the religion at all, and the religion and vice versa. That is the scenario in the Western concept of secularism. Whereas in the Indian context, there is a limited the state interferes whenever there is a necessity, and this act is an example of the secular nature of our country. Now let us see the next point. As a result, religious tolerance and equality of treatment of all religious groups are crucial components of secularism. So Indian secularism is based on equal respect to all religion. In India, secularism does not imply irreligion. So in India, the state interferes with the religion whenever it is a necessity. But in the Western scenario, this is not the case. The state will not interfere with the religion and vice versa. Except in the instance of Ramajanmabhumi Babri masjid controversy, which is already in court. It tries to preserve the religious character of places of worship as it was in 1947. So one of the exception of the Places of Worship Act is the Ramajanmabhumi and the Babri masjid controversy. It is because that at the time this act was enacted, this case was already in the court. So we cannot apply this act to the Ramajanmabhumi and the Babri masjid controversy. That is the only exception to this act, and this act covers all other places of worship in the country. The then Home Minister said the law was introduced as a measure to provide and nurture our beautiful traditions of love, peace and harmony when it was first introduced in the Lok Sabha. So one of the main purpose of this act is to maintain love, peace and harmony among various religious groups in the country. So the major significance of this act in short is it is to maintain the love, peace and harmony among various religious groups, and its another significance is that it upholds the concept of Indian secularism. That is the major significance of the Places of Worship Act. Now let us see what are the exceptions to this act. The act did not apply to the disputed site of Ayodhya. Due to this exemption, the trial in the Ayodhya case continued even after the law was enacted. As we already discussed, the only exception to this case is the Ramajanmabhumi and the Babri masjid controversy. And another exception to this act is the ancient and historical monuments and archaeological sites, because these monuments and archaeological sites are covered under the Ancient Monuments and Archaeological Sites and Remains Act of 1958. So the historical monuments and the archaeological sites are covered under the Ancient Monuments and Archaeological Sites and Remains Act of 1958. So they do not come under the Places of Worship Act. That is also an exception to the Places of Worship Act. Now let us see what are the criticisms of this act. A legislator has challenged the law, claiming that it is anti-secular. So one of the major claims of criticism against this act is that it is anti-secular. That is one of the major criticism of this act. Also argued that August 15, 1947 cutoff date is arbitrary, irrational and retroactive, and that it prevents Hindus, Jains, Buddhists and Sikhs from petitioning courts to reclaim their houses of worship. It claimed that fundamentalist barbarous invaders had invaded and encroached on such areas. So some people are arguing that the cutoff date, August 15, 1947, that is at the time of the independence, is arbitrary and not rational and is retroactive. So as we all know, in the ancient India, the majority of the rulers were Hindu and the temples used to flourish during that time. And when it comes to the medieval time, India was mainly ruled by the Muslim rulers. So during that time, people are claiming that they used to destroy temples and build mosque on such places, and they are basically encroaching the temple territory. So, by setting the cutoff date at 15th August 1947, mainly the Hindus, Jains, Buddhists, and the Sikhs will not be able to reclaim their houses of worship, which was invaded in the past. That is another major criticism of the act. Next point is right wing politicians opposed the measure from the start, claiming that the center lacked the authority to act on pilgrimages or burial grounds which were covered by the state list. So, pilgrimages and the burial grounds are actually part of the state list. So, the state has the authority to make laws regarding that. So, the right wing politicians are claiming that center lacks the authority to make laws on such subjects in the state list. Another critique of the law is that the date of independence is used as the cutoff, implying that the status quo established by a colonial power is deemed final. Now let us see what is the way forward in front of us. India was not a constitutional democracy before August 15, 1947. There was no rule of law during the medieval period when a temple was allegedly destroyed. So, India is not a constitutional democracy before August 15, 1947. And during the medieval time, there was no rule of law and the system was different. In the past, the rule of law did not exist and the polity was characterized by an expansionist attitude. The medieval polity was quite different from the modern Indian political entity. So, the political scenario of the modern India and the medieval India are different. In the medieval India, they mainly followed an expansionist policy. But today, we live in a modern democracy with constitutional values and follow the rule of law. The recent incidents appear to be a part of an agenda to create deep communal divides and serious injuries to peace and harmony and undermine the country's social and political fabric. So the various controversies that is happening nowadays, like the Babri masjid issue and various movements against the Places of Worship Act, is actually a part of the agenda of various external forces which are trying to destabilize and disrupt our society and cause various communal divide and also to affect the peace and harmony of our society. So the way forward in front of our government is to promote communal harmony among various people by providing literacy, and also the government should adopt various measures to control the various external and internal factors which try to disrupt our society. That is a major way forward for our country. The Supreme Court in the demolition of the Babri Masjid has described it as a criminal act. The court said that the state has a constitutional commitment and constitutional obligation to uphold the equality of all religions and secularism, which is a part of the basic feature of the constitution. So the Supreme Court, the apex court of our country, described the demolition of Babri Masjid as a criminal act, and the court also said that the state has an obligation to uphold the Indian secularism, that is equal respect to all religion, which is also part of our basic structure of the constitution. The court concluded that the Places of Worship Act 1991 is necessary for upholding our commitment to secularism under the Indian constitution. So the Act of 1991, the Places of Worship Act of 1991 is very necessary for upholding our commitment to the secularism. So, the government, administration and courts must decide the case based on law and constitutional values instead of emotions and majoritarianism political pressure. So, in the Babri Masjid case, the government, the administration and the courts must decide the case based on law and the various constitutional values, and they should not act on emotion and the political pressure, so that equality is ensured for all religion in the country. With this, I am ending this lecture. Hope you like this video. Thank you.